Well, good afternoon, ladies and gentlemen. I'm going to try and keep the politics and economics out of what I say and stick, by and large, to the legal facts, as it were, because I think it's fair to call them that. Most of the issues I'm addressing are legally quite clear. There aren't that many grey areas. Rather than, however, the politics do tend to intrude whenever one talks about this subject. And I think the one reason why I was particularly keen to address this from a legal point of view is that I found in casual conversations with people, particularly those involved in what is generally the Eurosceptic movement, that there are a lot of misconceptions running about as to what would happen and what the status of particularly of our international agreements would be were we to exit the European Union. Now, the process of exit is provided for in Article 50 of the Treaty on European Union. Just briefly, that contains a unilateral right for any member state to withdraw from the European Union by giving notice to the Council of Ministers, and in the absence of an agreement extending the period of exit, the European treaties cease to apply to that country 2 years after the date when it gives notice. The clause also provides for the prospect of negotiating both an agreement on the transitional arrangements, which would obviously be complex, and also an agreement on a future association of some kind or other. Those are provided for in the clause, but of course there's no guarantee that either such agreement would necessarily be offered on acceptable terms or could be negotiated within that 2-year period. But what is quite clear is that if such agreements were not able to be negotiated, the exit from the European Union would take place on the second anniversary of giving notice, regardless of any attempts that might be made to delay or obstruct it, unless the withdrawing state itself agrees to a more extended period. Now, coming back to what happens, we have a very large number of international treaties and arrangements in this country, some of which are traditional treaties to which we are a party as a state. For example, the United Nations Charter and the European level, there are a large number of treaties which are multilateral treaties adopted via the Council of Europe. Generally speaking, those would be unaffected by the United Kingdom's withdrawal from the European Union. They would just carry on very much as is. But large aspects of our international relationships are now conducted in one way or other through the European Union. And it's particularly that area that I need to focus on as to what would happen. And now, to address one misconception that I've heard, there is a misconception running around that the Treaty of Lisbon effected a significant change in the status of the European Union and its international treaty-making powers. Now, that is not so in the trade and economic field. The Treaty of Lisbon made, in effect, no difference. Where it did affect it was in the common foreign and security policy area. That's a specialist area I don't have time to address in my 15 minutes this afternoon. But in the trade field, the point is that the EEC, in its original form under the Treaty of Rome, had international legal personality and adopted treaties, international agreements in its own name from the very beginning. And it is that same power to conclude international treaties which has progressively expanded in scope, but not in nature over the years. And the reason why that such an explicit international power to make agreements, international legal personality, was conferred on the EEC is because the EEC, from its inception, was a customs union and not a free trade area. It's worth bearing in mind, I think Ruth explained this, these are fundamentally different in concept, although superficially they might seem the same, in that in both cases you get tariff-free trade in goods between the members. But a customs union is quite different because what happens is once goods cross the external border of the customs union in any territory, they can then freely circulate within that territory with no further tariffs. And the tariffs are and have to be uniform round the external border of a customs union. Otherwise, it doesn't work. Otherwise, all the goods flood in through the lowest tariff port and then spread out across the customs union. So they have to have, you then have to have a tightly harmonised system to make the tariffs the same. And also another consequence is that you have to conduct your international trade negotiations collectively, that you cannot conduct them individually as a member state. You cannot have one member state going off and doing a free trade deal with a third country and not others. A free trade area is quite different because the freedom to trade without tariffs applies only to goods which originate within the free trade area. This means that each country can set its own external tariffs and can conduct its own external trade relations. However, the downside of a free trade area is there continue to be customs controls based on enforcing rules of origin at the internal borders of the free trade area. And that is a significant factor, which is why, from some perspectives and certainly in tightly integrated industries, there are considerable advantages in being in a customs union rather than the free trade area. The international legal personality of the EEC, as I say, was put in there in order to permit it as an entity to conclude international trade agreements in effect collectively on behalf of the member states. Now, some people, another misconception, perceive what would happen if a member state withdraws from the European Union as being an issue of state succession in international law. What I mean by that is, for example, when a big state like the Soviet Union breaks up into component entities, there's quite a lot of international law about what happens to the treaties that were formally concluded by the Soviet Union and whether they bind and can be enforced by the individual republics. However, this is not, emphatically not, an issue of international law of state succession. That is not engaged. It is clear, if we take international trade treaties concluded by the EEC, then the EC, then now as the EU, but in their own name, that an exiting member state would no longer be party to them. And for example, the free trade, external free trade agreements that Ruth mentioned, we would no longer, if we exited the European Union, be a party to the European Union's free trade agreement with South Korea. That is not to say, and this moves to a political rather than a legal question, that the South Koreans wouldn't be willing to agree to an agreement with similar terms, at least on an interim basis, to keep the free flow of trade going. But it would be necessary to negotiate extensions of the existing free trade agreements by consent of the international counterparties. Now, there's a more complicated area, which is the area of mixed competence. And this is a doctrine which has been developed by the European Court of Justice. In addition to the explicit external competence of the EEC to conclude international treaties, the Court of Justice has developed a doctrine of implied external competence, under which what we'll call it now, the European Union, has an implied competence to negotiate external agreements relating to subject matter in relation to which it has internal competence. And this is a much wider field than the field of tariffs and free trade in goods. It's capable of covering any field in which there are internal regulations and directives. Therefore, however, the European Union is not omnicompetent. And it frequently happens that in international relations you have agreements where that cover matters both that are within the competence of the EU and matters that are still within the competence of the member states. I've used the word still because, of course, this is a reflection of the sort of doctrine of the European Court and other European institutions that there can only be a one-directional flow of competences from member states towards the European Union, without necessarily agreeing with that myself. Now, what happens there, a very important example of a mixed competence agreement, is the WTO agreements. And the WTO agreements, actually the European Community, as it then was, is itself a party to them, but also all the member states are also individually parties. And the reason for that, and there's a very long and complicated opinion case by the European Court of Justice called the Uruguay Round Agreements. The reason for that is this mixed competence matter, that as between third parties, third countries, the European Union itself is responsible for compliance with obligations within the scope of its own competence, such as those to do with tariffs, whereas the member states are responsible vis-à-vis third countries for compliance with obligations outside EU competence. And this is both a moving frontier, also not easy to pin down, and can cause some difficulties for third states to identify who may be responsible in relation to any particular policy area, but that is the position. Now, what would happen under those agreements if the United Kingdom were to exit the European Union is fortunately fairly straightforward. It would simply mean that we would reassume full 100% competence for all matters within the scope of the WTO agreements. Now, so that's fairly straightforward, and I concur with Ruth that we would automatically remain as within the WTO agreements, but that our competence would expand, and indeed, as between us and any other WTO member, we would enjoy rights and be subject to obligations across the board, including with the European Union itself. So we could, in fact, in principle, invoke the WTO disputes procedures in the event of unfair trading practices conducted by the European Union after exit. A possibility we cannot invoke at the moment because the Treaty on the Functioning of the European Union explicitly prohibits the submission of any interstate dispute to any means of settlement other than the Court of Justice of the European Union. However, there's another category of agreements to which both we as a member state, all member states, and the European Union itself are parties, and those are a number of association agreements between the EU and non-member states. Now, those are the reason for those, for the member states, however, being parties to them, is the same as for that same reason as for that in other mixed competence agreements. It's that these association agreements frequently extend to cover matters outside the EU's competence. However, if we exit the European Union, it would not be possible for us to continue to be parties to these agreements, because the way they are structured is they're bipartite. It's the European Union and its member states on the one part, assuming certain obligations, and the third state assuming certain rights or obligations on its part, so that our exit from the European Union would mean exit from those. And the most significant, I suppose, single association agreement falling in that category is the European Economic Area Agreement. It is not the case, as I surprisingly heard it said, that we would automatically remain members of the European Economic Area if we were to exit the European Union. If we were to exit the European Union, we could no longer remain within the EEA agreement unless it were amended to change us from the category of being an EC member into the category of being an EEA member, an external member, and effectively push us onto the other side of the table in the context of the mechanisms under that agreement, the bilateral or multilateral mechanisms under that agreement. Now, that could be done, but that would require everyone's agreement and consent. So that would not be possible. We couldn't insist on remaining in the EEA were we to leave the European Union. I say nothing further about the wisdom of wanting to stay in the EEA, apart from it does seem to me rather an odd thing to want to do to continue to be subject to all the effectively all the obligations of membership to comply with burdensome regulations, and give up your right to vote on whether they are to be imposed or not. But there we are. Finally, just a brief word about the EFTA agreement. The EFTA agreement is now an agreement between 4 countries, between Switzerland, Liechtenstein, Iceland and Norway. The United Kingdom used to be a party to it, indeed was the founding driving force to it. We ceased to be a member in 1972. We could apply to rejoin. Maybe they'd welcome us back, hopefully they would. What it governs, however, is free trade in goods between the EFTA member states. It doesn't automatically give us any ticket back into free trade with the European Union if we were to join it. That at the moment, well, it was originally governed by a series of bilateral agreements between the EFTA states and the EEC, only one of which still survives, which is the Switzerland EEC 1972 bilateral agreement for free trade in goods. The other 3 have been superseded by the EEA agreement as between those countries and the European Union. The other possibility which Ruth indicated, however, if we were to apply to join EFTA, whilst it wouldn't absolve us from bilaterally renegotiating a relationship with the European Union, is the possibility of joining in the EFTA umbrella body, in effect, in the negotiation of free trade agreements with third countries, where EFTA has been notably more successful than the European Union in negotiating such agreements, possibly because they don't have awkward people on board like the French, who insist on protectionism for the French film industry and muck up the EU-US negotiations in that regard and so forth. But thank you. That's a very quick, condensed survey of a complex subject.